Good afternoon, everyone. Welcome to all of you to our debate on the Digital Markets Act, the role of gatekeepers. Today's debate is hosted by our member Alex Agius Saliba, MEP with the S&D Group from Malta, member of the IMCO Committee at the European Parliament and Rapporteur for the Digital Services Act. Welcome, Alex, and thank you very much for taking the lead on this debate and on this very topic. We have received over 150 registrations for this debate today, which simply confirms the high interest from the members of our forum, but also representatives of other EU institutions. As you may know, on the 15th of December last year, the European Commission published its proposal for a regulation on contestable and fair markets in the digital sector, known as the Digital Markets Act. And today we will be joined by 4 experts to discuss the policy goals behind the proposal and the expected impact on the markets. We'll focus in particular on the designation of gatekeepers, including who they are, the list of obligations and prohibitions, and their implementation, and on the scope and timeframe of the market investigation tool. Let's give a warm welcome to our speakers, starting with Inge Bernaerts, Director for Policy and Strategy at DG Comp, European Commission. Welcome, Inge. And then to Vincent de Dorlodot, who's Senior Vice President of EU Affairs at Bertelsmann and RTL Group and Head of the Brussels Liaison Office. Welcome, Vincent. We're also joined by Hendrik Bourgeois, Head of Government Affairs for Europe and Russia at Apple, and by Fiona Scott Morton, Theodore Nierenberg Professor of Economics at the Yale University School of Management. Thank you all very much for joining us today. As always, after listening to our speakers, there will be an exchange of views with the audience, which we'd like to be as interactive as possible. It will take place in the Q&A session, and we will guide you there later. We're all set to start now, and Alex, the floor is yours. Over to you.
First of all, I would like to thank you and also the European Internet Forum for organizing this very timely debate, and it's an honor to be here today with the fantastic speaker lineup to discuss the DMA proposal, which is a very important topic, generating a lot of interest, and this can also be witnessed today by the good number of participants who are interested in this debate, because ultimately this is a very timely debate, and definitely this is one of the first discussions being held on the Digital Markets Act proposal being published by the Commission on December 14. And I am really looking forward to the talks today, and also to the different questions that we will have to also answer from the good audience that we're going to have. First of all, there is no doubt that when adopted, the Digital Markets Act will have a massive impact on the digital world in Europe, but also a massive impact in other regions and other continents worldwide. After its publication in December, the attention that the DMA proposals got came to no surprise to us, only confirming the importance that this legislative proposal will have for the digital world. This is the first time, and I have to say it is a very courageous step taken by the European Commission on setting the record straight and leveling the digital world level playing field. When adopted and ultimately enforced, the legislation will have significant consequences for the competitive digital landscape in Europe, and will finally address the long overdue problems and also harmful business practices of companies that fall under the definition of gatekeepers. I am glad that the Commission has been open to the Parliament's suggestions regarding the ex-ante instrument that we have moved forward. It's a whole chapter in our own legislative initiative that was adopted last October by the Parliament's plenary, and have taken on board some of our proposals. And I am still analyzing and processing the details myself. We say that the devil is always in the detail, and here we have a lot of details to analyze. Still, there is no doubt that the Digital Markets Act is a good effort. It's a good effort from the Commission to redistribute market power away from a few gatekeeper companies in an attempt to create a level playing field for other competitors, for European competitors, for SMEs who want to enter in the market. And the European Parliament has agreed in its DSA report that by regulating large platforms, an internal market instrument imposing ex-ante regulatory remedies on these large platforms basically has the potential to open the markets to new entrants, to SMEs, to startups, and also thereby also promoting directly a higher level of consumer choice and also driving innovation beyond what can be achieved by traditional competition law enforcement by itself. And that is why I welcome the Commission's proposal, which rightly so targets gatekeepers, big tech companies, and aims to create a safer online environment and also increase transparency, increase accountability of these content hosting companies. Gatekeepers raise essential concerns in the new digital markets. They basically are dictating our rules. They are an unavoidable trading partner. They can undermine trading conditions, and also they can engage in harmful business practices. They have access to vast amounts of data. And what is more important is that they can lead to a consumer lock-in effect and make it very difficult, sometimes impossible, for small companies to enter the market. Such behavior leads to the tipping of the market, distorting competition, and ultimately harming consumers and also restricting their choice on the market. That is why DMA is addressing gatekeeper platforms, very large tech companies that sit in between other businesses and their consumers and control core services such as search engines, social and video sharing platforms, online marketplaces, messaging services, and also advertising products. Although the European Commission hasn't named specific companies, the more stringent rules will apply to those with European revenues of at least 6.5 billion or at least 45 million users across Europe. I welcome the fact that there are real penalties and also, and I think more importantly, structural remedies and also a ban on mixing data. The proposal specifies fines of up to 10% of a company's global revenue with a threat of breakup for repeated offenders' operations, showing the Commission's serious intentions on this matter. This is not a joke. The proposal is also granting the Commission significant powers, I must say, including the ability to also amend the regulation's content if necessary. The legislation will regulate, first of all, anti-competitive behavior and practices such as self-preferencing or not letting users uninstall pre-installed apps or other software, introduce also interoperability requirements for business, which is very important, regulate throwing up unjustified barriers to access digital marketplaces, and also regulate the sharing of mixed data and giving the green light for intended mergers and also other acquisitions. These are some of the key elements of the DMA. The Commission's proposal is, I believe, just a starting point. It's a starting point that will go through many discussions, many amendments, and a lot of lobbying before it is ultimately adopted. However, I am glad that we have started this conversation on a positive note. There's a lot to like in the proposal, but at the same time, we believe that there is also a lot of room for improvements and also a lot of room for more ambition to create a more contestable environment online.
Thank you very much, Alex, for setting the scene so well and touching upon some of the key aspects of this proposal. Note taken about the need to be even more ambitious. But let's hear from the European Commission with Inge Bernaerts at DG Comp. Over to you, Inge.
Thank you very much, also from my side, to the European Internet Forum for hosting this indeed very timely debate on the Digital Markets Act, for which we tabled our proposal on the 15th of December. So we are at a very early stage of co-decision procedure, and I'm very happy to be here with you today to try to explain some key elements of the Commission proposal. Thank you also to Mr. Saliba for setting the scene so well today. But not just today, also already in the European Parliament report, indeed, to which you referred and in which you called for an internal market instrument imposing ex-ante regulatory remedies on large operators with significant market power. And that is exactly what the Digital Market Act aims at. The objective of the Digital Markets Act is, in fact, two ways to ensure that markets remain open and contestable despite the presence of gatekeepers in core platform services, so that businesses in the EU, large and small, can compete fairly online as they do offline. The second objective is to avoid unfair conduct by such gatekeepers towards either their business users or final consumers. And the instrument that we have chosen for this objective is one of ex-ante regulation, an instrument in which do's and don'ts, obligations and prohibitions, are set out in the legislative act itself. And those obligations and prohibitions will apply automatically to designated gatekeepers. So contrary to what exists in the UK, for example, or it's now foreseen in the German Competition Act, we have not chosen for a case-by-case assessment where remedies are tailored to each individual companies, but we have deliberately made a choice in favor of speed and legal certainty, which we believe is created by specifying in the Digital Market Act itself the obligations and prohibitions that will apply. The designation as gatekeeper does require a Commission decision, and the designation mechanism is one based on a combination of quantitative and qualitative criteria. The key principle is that you can be designated as a gatekeeper if you, as an undertaking, have significant impact on the internal market, if you operate a core platform service which serves as an important gateway for business users to reach end users, and if you enjoy an entrenched and durable position for that core platform service. If you meet the quantitative thresholds which are stipulated in the Digital Markets Act, they relate to turnover, to market value, to numbers of business users and end users, and to whether those figures are met for the last 3 financial years. If you meet those quantitative thresholds, then you are presumed to be a gatekeeper and you can be designated fast. If you do not meet the quantitative thresholds, you can still be designated, but then on the basis of a more detailed, full-fledged market investigation to verify whether, as an undertaking, indeed you meet the substantive criteria which are set out in the Act. But once designated as a gatekeeper, as I indicated before, this is a core feature of the DMA that the series of obligations and prohibitions foreseen in Articles 5 and 6 will apply to you automatically. There is some room for a dialogue on the implementation modalities for the provisions stipulated in Article 6. And there is limited room for a temporary switch off of some obligations and prohibitions in case of overriding public interest. But as such, the idea is that the obligations and prohibitions kick in automatically once you are designated as a gatekeeper. You'll find in the Digital Market Act proposal a system of enforcement where the Commission indeed acts as regulator at the European level. I think that's quite a novel feature of the DMA. And the Commission having investigative powers to implement that task, investigative powers quite similar to those present in competition law. You'll also find due process rights, which are stipulated. Of course, the decisions taken under the Digital Markets Act have far-reaching consequences for operators. So it's only normal that the due process rights are also preserved. That's an important point for us as Commission as well. As Mrs. Saliba indicated, the sanctions foreseen in the Digital Markets Act for violating the prohibitions and obligations contained therein can go up to 10% of turnover. And in case of systematic non-compliance, which we hope, of course, will not occur, because the idea is that the Digital Markets Act will have a preventive effect on the market, but should nevertheless systematic non-compliances occur, there is the possibility, on the basis again of a market investigation, also to adopt behavioral or even, in case that's necessary, structural remedies. So that in a nutshell, in terms of some core building blocks and some key features of how the proposal, as we have foreseen it, is conceived. Now, where are we in the process? As I said, we're starting. And no doubt, that Mr. Saliba also said, there is a margin to improve the text. We as Commission look very much forward to engage with both Council and Parliament. The discussions on the text have started already in the Council Working Party, where the file has been attributed to the Competition Working Party. In the Parliament, the file has been attributed provisionally to IMCO, but I understand that other committees are also taking a keen interest. But once their decisions on attribution are taken and the rapporteurs are appointed, we look forward to really engage with the Parliament as well. We have already been presenting the initiative also in the IMCO, taking active part in events such as this one, to make sure that we can present the proposal as we have foreseen it. And as I said, we very much look forward to engage with the co-legislators and to facilitate what hopefully will become a fairly rapid legislative process. Thank you very much.
Thank you very much, Inge, for being available to join us at our forum at this early stage of the proposal and presenting it to us, and be open to exchange views with stakeholders. So let's bring in some of these stakeholders, starting with Vincent, the Dorlodot with the Bertelsmann and RTL Group. Over to you, Vincent, for your views.
Yes, good afternoon, everyone, and thank you to the European Internet Forum for hosting this interesting event. I found the comments of Mr. Saliba, political comments, very interesting, and the very clear overview of the Act by Mrs. Bernaerts equally interesting. So I will give you a few thoughts on this recently proposed regulation. It was a long-awaited instrument by many companies in Europe, and certainly media companies. And let me say first maybe a few words about Bertelsmann. So the pandemic was and still is a huge challenge for us. But despite the hurdles and big drop in advertising revenues, for instance, we managed to do what we do best, which is to reach our audience with the best possible content, be it news, books, music, magazines, or TV series. Actually, we learned two lessons from this crisis. First, it revealed the importance of trusted media, I think, to support citizens during the crisis. And the crisis has also been for us a fast forward button rather than a pause button. And we clearly accelerated our transformation from offline to online models. We have, for instance, developed online video offerings. We have invested in new advertising technologies. We have launched a music business model that is really fully adapted to the digital world. But often, to reach our readers or viewers, the only way is to use the existing big platforms. There are certainly very useful intermediaries that have developed innovative technologies and services that we can't match and that we all use. But there are also our competitors. And their role and position was strengthened during the crisis, which means that the dependency is increasing as well. So there is a need for a rebalancing act, and in that respect, the Digital Market Act is one, amongst others, tool to ensure that there is a level playing field. And I'm glad to see that not only in Europe, by the way, that's a global issue now. It's acknowledged that there's a number of systemic problems that needs to be addressed. And the key issue for platforms is probably to take more responsibility, reflecting their reach and their influence on societies. That's the Digital Service Act component, and also the market power, which is the Digital Market Act component. The premise of the Act, I think, are that existing tools are not sufficient. And we agree with the big shift that the Commission is doing from I would say, towards prevention more than cure. And we think that the DMA can make a difference. I will not list the Article 5 and Article 6 obligations. You surely have read these 18 commandments. I see, by the way, that the Commission is a bit more exhaustive than GOT, but they're based on extensive experience of the Commission in various cases, and I think also the large consultation that took place last year. So I would like only to highlight some overarching principles which should support any such list of do's and don'ts now or in the future. So a principle of non-discrimination, a principle of real consumer choice, a principle of transparency, and in that respect, for instance, we were pleased to see rules on advertising transparency, both in the DSA and in the DMA, including on the distribution of the revenues and on audience measurement. And also a principle of guaranteed access to data related to the content that we produce and distribute. For media companies, really accessing their own data is really strategic to improve and adapt our services or content, but also to monetize them via personalized advertising. So to complete the positive aspect of the DMA, it seems that the Commission has sufficient power to enforce the rules, but it also assumes that it will have enough resources to do it, which is not a trivial question, I think. And all this being said, there's of course a number of questions or point of vigilance, and I will list some of them, and that will surely feed our debate this afternoon. So first, are we sure that the definition of gatekeepers and core platform services catch all what it needs to catch? It will of course depend on how people will consume media in the future, difficult to guess. But we can think, for instance, that the development of smart speakers or voice search. Second, are we sure that the many procedural aspects for designating the gatekeepers and the possibility to contest this status will not unduly delay the implementation when time is really of the essence? The third question is probably how will, and that's a question that I asked to the Commission, how will Article 6 be applied concretely? What means to be further specified? I didn't find much in the recital on that, and I'm a bit afraid that this could be quite complex to handle and could lead to endless discussions. It should not certainly become a quasi-ex post control. The fourth question is, could we go a bit further on some rules based on the principles that I mentioned? 5, what will be the interaction between existing and future member state rules, which could be guided by other goals like media pluralism, for instance? And eventually, last question, could the resources of national authorities be injected in to some extent in the enforcement process, which not entirely rely on the Commission? I don't know whether I'm still online. Okay, can you hear me?
Yes, Vincent.
Sorry, I don't see you anymore, but okay. It's time to conclude anyway, I guess. The Digital Market Act is a great initiative. and a useful text. It's now up to the Parliament and the Council to improve it, as Mr. Saliba said, and they will surely do a good job at it. The Parliament's own initiative reports have indicated a good understanding of the matter and a high level of ambition, so we're definitely keen to engage with all the MEPs involved. And I would simply suggest to keep the following elements in mind. Time is of the essence. So the DMA is in a sense long overdue. It addressed very pressing issues. The second point is ex-ante rules are deemed to be clear and efficient way to deal with market inefficiency. So when the text will be final, it should be simple, efficient, and adapted to fast-moving markets and practices. And last but not least, beyond pure economic or technical consideration, one should not forget that one of the key questions is, how can we allow cultural and creative industries to compete fairly, which is a precondition to guarantee the production of rich and diverse content. So I think that the future of content creation in Europe is at stake here. Thank you for your attention.
Thank you very much, Vincent, for sharing your views and for raising some questions already, which I'm sure can be addressed later during our Q&A session. I've never heard the European Commission being compared to God before, but I think we understand what you mean. We will go on with our last speaker, last but not least, of course, Fiona Scott-Morton with the Yale University School of Management. Thank you very much for joining us, Fiona, and over to you for your views. Your microphone.
Sorry about that. Thank you very much for the invitation to participate. It's a great pleasure to be here with so many expert voices. I wanted to start by first disclosing that I do expert witness work. In particular, just now I'm working for Amazon on an antitrust matter. On the DMA in general, I think it's a really great first step. There is a lot to like here. I think in particular, what I appreciate about the DMA is that it's reacting to the last 10 years of antitrust enforcement, both in the EU and the US, where we learned that this just was not enough. I'm a big fan of antitrust. I think it's necessary and valuable as an area of enforcement. But in the EU, there's been 10 years of cases against Google and no change in market structure. In the US, we had absolutely nothing going on until 3 months ago, when suddenly the dam broke and there's a flood of cases, but those cases will take 6 or 7 years to resolve by the time we have all the appeals. And I think there's just a hunger to move faster than that. And certainly digital and technology markets move faster than that. So in addition to antitrust not being quick enough, I also think there's a really important kind of business model that is captured by the DMA that's not captured by antitrust enforcement, which is the business that was lucky, that got network effects on its side at the right moment, and because of the network effects and economies of scale, gathered tremendous market power, and now has an entrenched position and is taking all the surplus. And we don't think that there's an efficiency reason why that should be the case, and that area would benefit consumers more if it were subject to competition. So this is where we get the fairness piece. Why is that lucky platform extracting all the surplus? And we get the competition piece. What we'd really like is to have more contestable markets in the sense of lower barriers to entry, so there can be more entry, more competition, and more choices for consumers and businesses both. What do I see these regulations doing? I think, as Ingrid said, gatekeepers are defined very simply by size and have they been there for 3 years. And this is completely rigid and probably a good choice in that it saves years of litigation. It's certainly fast. It certainly creates legal certainty. But I think that then in combination with rules that have no flexibility, you're setting yourself up possibly for the sort of clash that Hendrik was speaking about. I think that there's an infinite variety of strategies, of kinds of markets, of products, of consumer behavior, and these things will never be neat. And if you set up a system where there's just no escape hatch when the situation doesn't match what the rules envisioned, then inevitably there will be a clash down the line and some kind of unintended consequence or some kind of business that consumers would like to use and cannot because of these rules. So I do think it's worth thinking carefully about a kind of evaluation that would be sufficiently strict, put burdens on the firm to explain what was good, have as a goal both of these factors, fairness and contestability, but would allow companies to make sure that they're being constrained by rules that are intended for them to be constrained by, and not rules that are accidentally constraining them. The most exciting part about the DMA to me are the parts that are more general. A lot of these rules seem to be taken from past cases, like we can identify Spotify and we can identify Google in the set of conduct, but just those names have been taken out and they've been generalized. And I wrote a little piece with Christina Cafara and Vox about kind of trying to re-identify all the rules. And those, I think, are the ones probably most likely to be problematic. But the ones that are exciting to me are the general ones that talk about portability and interoperability. I think this is a really exciting area to make real progress in lowering entry barriers. If markets are interoperable, if the platform and all the products are interoperable, that means that they hook up to each other. That means that there aren't switching costs for consumers. That means that economies of scale and network effects occur at the market level. And that makes it very exciting for a new entrant, because they can enter and get business if consumers are attracted to their product. So this is a really excellent way to go. It doesn't require a heavy lift in the sense that what's needed is a common standard for interoperability, and then the market takes care of itself. Firms enter where they want to, consumers move their business around with no friction, and we have big network effects. So I think interoperability on a kind of moment-by-moment basis, and portability, where a consumer can take her data from one place and bring it to another, also promotes entry and promotes competition. So these are two big areas that I think are really exciting. And then a third one, which is throughout the rules, is really a broader view of consumer protection. Like consumer protection includes small businesses. There should be transparency about lots of things. We should be told how ad markets are working. We should be given control over our data. Firms should be prohibited from merging different kinds of data that consumers don't want merged. And if you look at all of those provisions in the DMA, there are really quite a few. And I would characterize that as a kind of a more robust, digitally enabled consumer protection agenda. And I think that's really healthy and good, and stands to make these markets more fair, because people will understand what's happening to them, and so will businesses, and more contestable in the sense of lowering barriers to entry, where an entrant might be offering better quality or a different way to do something that's less invasive in terms of privacy, and consumers might want that. And if they understand what's being offered and they have control, then they are able to choose it. So I think these are great directions. I think there's some adjustments that could be made to make it a more effective law that protects consumers but also enables productivity and efficiency. But in general, we're headed in a great direction. Thank you.